Tonight, Attorney General Merrick Garland says that tireless work by his Justice Department helped secure the seditious conspiracy conviction against the leader of the Oath Keepers, Stewart Rhodes. We have an exclusive interview right now with Rhodes' attorneys, James Lee Bright and Phillip Linder. CNN Sarah Seidner is also back with me to take part in this conversation. Thank you both for joining us this evening. James, I want to start with you. You have said this was a fair trial, that government prosecutors, quote, took us to task, which is quite honest. So how significant do you think it is that Rhodes was found guilty of seditious conspiracy, a rare conviction?
It is a rare conviction. Thank you for having us. I really appreciate it. I do overall believe that we got a fair trial. I think the jury stayed out 3 days. And as you had a guest previously this evening detail, they kind of came back with a very interesting selection of not guilty verdicts and guilty verdicts. I think that shows the attention to detail that they had and the attention that they gave to the verdicts and the trial itself. The government did take us to task. This was a brutal trial for all parties, long, extensive, lots of evidence. And, one person I want to compliment is Judge Mehta, incredibly intelligent man, and I loved his tone and demeanor in the courtroom and how he ran the courtroom. In terms of Mr. Rhodes and his conviction for seditious conspiracy, I would respectfully still state that while I respect the jury's return on that, based on the evidence that I feel was presented and what was given to the jury, I actually disagree with their finding on that specifically.
Right after January 6th, Phillip, Rhodes said that he, quote, his only regret he made in a recording that was later played by the government. Let's listen to that only regret.
My only regret is they should have brought rifles. I'll tell you what, if President Trump's going to do the right thing, then I agree it was the wrong thing to do. If he's not going to do the right thing, he's going to just let himself be removed illegally, then we should have brought rifles. Could have fixed it right then and there.
Should have brought rifles. He regretted not bringing rifles. Phillip, does he have any regrets now?
Yes, Mr. Rhodes regrets that some of the Oath Keepers actually went into the building. They were not directed to go into the building. And the evidence came out in trial that those people that went in the building were off mission at the time. And he regrets that officers got hurt. They weren't hurt by his people, but that officers in the building did get hurt by people in the crowd. And that is a regret of his. But as the evidence showed, he didn't direct anybody to go in. There was no plan to go in, and the few that did so on their own volition.
All right, I want to bring in my colleague, Sarah Seidner. She has a question for you. Sarah.
I do. James, I want to start with you. I sat in this trial watching you and two other attorneys took this very difficult case. There was, like you said, like a mountain of evidence. But Mr. Rhodes testified in his own defense, standing by this baseless claim that the 2020 election was, in his words, unconstitutional. And he wanted to testify. That seemed to be made very clear. Can you tell us whether or not you tried to dissuade him, or if you regret that he testified on his own behalf, which is also a very rare thing, dealing with a very rare charge?
Absolutely, Sarah. Good to see you again. When Mr. Linder and I were first hired on this case, January 24th, and we went and met with Mr. Rhodes, he set out two preconditions for us to represent him. One, he would testify at his own trial no matter what. Two, he would never accept a plea offer. That's been made clear in the case, made clear to the court. So it's nothing that we could have dissuaded him from doing to begin with. He's a Yale-educated lawyer. He's very intelligent, whether an individual chooses to agree or disagree with his ethos and his belief systems. And we did, with that kind of client, what was necessary. We admonished him thoroughly as to the pros and the cons, legally and strategy-wise, regarding waiving the Fifth Amendment and testifying. So if in his case, it was never an option. It was not something that we were going to be able to keep him from doing. In terms of the unconstitutional nature of the election, Mr. Rhodes has done an enormous amount of research, and he'll point you to Article 2 of the Constitution that requires the legislatures of each of the 50 states to approve modifications of
All right,
I think
yeah.
Mr. Linder,
We've lost him there.
we're hearing
structure of them.
a little bit of the testimony that we heard from Stewart Rhodes at the time, and I don't know if we still have Mr. Linder up. Oh, okay, James, you're back. All right, I do have a question here because you have said that you are going to appeal, and this is for either you, Philip, or you, James. You have said you're going to appeal. On what grounds? Since you said that you felt like this was a fair trial and this jury came back with a verdict you didn't agree with, but that it was fair.
And I'll address this issue.
I'll let Mr.
We
Linder field that
believe.
question then.
Thank you. Thank you, Sarah, for the question. It's a great question. We feel that we spent a lot of time over a week selecting a jury, which we thought was a fair jury for the district. And based on their verdict, you can see that they've come down with, they individually went through each defendant and each count and rendered separate decisions for each of those, which is what they're supposed to do. So we feel, and they spent a lot of time doing that, several days. So we feel that we got a fair trial in that respect. However, as you know, and as you watched, there were things that the government presented in evidence that we objected to, which we feel shouldn't have come into evidence. There were things that we wanted to present. The judge Mehta, even though I think did a fabulous job, he prevented us from presenting to the jury. So the jury didn't get everything they needed to get to really weigh everything. They got a lot of evidence, as you saw, they got tons, but there were things that they were prevented from seeing from us, and particular witnesses that we wanted to present that we were unable to. So based on that, we don't think that part is fair.
Well, it was a remarkable trial. Thank you both for joining us tonight. Thank you for your honesty. James Lee Bright, Phillip Linder, and of course, my brilliant colleague, Sarah Seidner.